Ghislaine Maxwell has petitioned the Supreme Court saying that it must throw out her underage sex trafficking conviction. And legally speaking, she has a point. I'm Jeannie Suk Gersen, a law professor at Harvard and New Yorker contributor. Here's what Maxwell's petition argues, why it could work, and what its larger implications could be. So, back in 2007, when Jeffrey Epstein was being federally investigated for sex trafficking of minors, he agreed to plead guilty to state law crimes and serve an 18-month prison sentence in Florida. In exchange, the U.S. Attorney for the Southern District of Florida promised that his office would not prosecute Epstein for the federal crimes under investigation. The wider Epstein scandal that blew up in 2018 was triggered by new reporting about that sweetheart deal. The 2007 agreement included the promise that the United States also agrees that it will not institute any criminal charges against any potential co-conspirators of Epstein, which Maxwell undeniably is. Maxwell's case raises an important question. Does one U.S. attorney's agreement on behalf of the United States bind federal prosecutors in other districts? The issue extends well beyond Maxwell, but she's the one who's asking the Supreme Court to resolve it. As a convicted sex offender serving time for trafficking underage girls, Maxwell is an unappealing messenger for this request, to say the least. But the case has wider-reaching implications. As the National Association of Criminal Defense Lawyers argued in an amicus brief, allowing the United States to escape a non-prosecution agreement would work a detriment on the entire plea system. Plea bargains resolve the vast majority of criminal cases. If a non-prosecution agreement on behalf of the United States does not actually resolve a defendant's criminal liability, then such agreements may become much less attractive, a result that neither defense attorneys nor prosecutors should want. In the lower courts, there's a clear split about whether non-prosecution agreements made in one district are binding in others. So it won't be surprising if the Supreme Court agrees to hear Maxwell's case. But there are also reasons the court might want to punt, aside from the fact that the justices may be loath to get involved in any aspect of the Epstein mess. You can read my analysis of the case and what the outcome could mean at NewYorker.com.